My name is Steve Fischbach. I'm litigation director at the Virginia Poverty Law Center, which is the state support center for all legal aids in Virginia. It's a pleasure and an honor to be here in this space with you. I like to know who's in the room so that we have an idea of like who we are engaging in conversation with. So if you're a frontline community member, could you raise your hands?
And shout.
Oh, that's right. How would you like us to do that? Do you want us to?
Say aye, whatever.
Okay. Actually, could you all just say I also?
Aye.
All right.
Great. How many are students in the room? Raise hands and then say I. How many are lawyers in the room? Okay, great. Great, and I'm sure I'm leaving out some sector. Academics? Okay. Now, did I get everyone? It may have left out some. Nonprofits or support organizations or allied organizations?
Aye.
Great.
I'm all of those things.
Great, okay. So I've been tasked to lead this off. I actually want to make my section much shorter. Actually, first, before I even start yapping, could I just ask the panelists, starting with Albert, to just introduce themselves, and if we could just go this way, that would be helpful.
Hello, I'm Elia. I am a staff attorney with the Civil Rights Education and Enforcement Center. I also am a blind person, and I use he, him pronouns.
Marsha Jackson, Dallas, Texas. I'm the executive director of Southern Sector Rising.
Omega Wilson, co-founder and co-director of the Western Revitalization Association in Mebane, Alamance County, Orange County, North Carolina.
Hi everyone, I'm Britney Wilson. I'm a professor at New York Law School where I direct the Civil Rights and Disability Justice Clinic.
Okay, so the part that I'm going to cut short was I was going to do like a primer on civil rights laws and what they are. Because we've been cut to an hour, all I'm going to say is we're going to be talking about primarily 3 civil rights statutes, maybe it's 4, I forget, but there's Title VI of the Civil Rights Act, which bars recipients of federal funds from discriminating on the basis of race, color, and national origin. There's Section 504 of the Rehabilitation Act that does the same, again, for recipients of federal financial assistance on the basis of disability. You may also talk about the ADA, right?
Yes.
Which is a broader anti-discrimination statute. There's also the Fair Housing Act that comes into play in the environmental justice space. And I just don't want to spend that much time going over these basics because the more important part will come from my fellow panelists. So kicking us off is going to be Marsha. Is your mic on?
No, it's on, but it's not working.
Okay, I'll hand you mine when I'm done. So, Marsha, can you tell us how you've used civil rights tools, including Title VI and the Fair Housing Act, to address the impacts of some zoning decisions that occurred in your community that affects the community's health and well-being?
Sure. My community, as well as myself, was harmed due to environmental racism right next to our home. My community is Black and brown. That we have the environmental issues that controlling and not so much letting us have home improvement. So what we did, I started out, and also my neighborhood and our neighborhood-led communities, we filed a housing complaint against the city of Dallas because they do receive the federal funding, and that limited us because of the environmental. We cannot get loans for home improvement. We cannot do any kind of home improvement, and our homes are less valuable now because of the environmental justice right next to us. We also, and I don't know if you want to discuss it, we also filed a RCRA, environmental law. It, as they spoke earlier, that it even went to appeal, because when we filed that, the city of Dallas did decide to file and move some of that chemicals, but we had to go to appeal, even though going to the appeal in Louisiana last year, that it was denied, in which we knew that, but we were still on record to let them know that we still have a voice and we could still file those. We're still going through the housing complaint. They have interviewed me, my neighbors, and other residentials. We have had 2 others join us in that complaint as well, and I think that it's moving really well for that. We haven't had a decision yet, but it is on notice with the city of Dallas, and that's included that when they did in 1980, they rezoned the issues in Dallas, but they did not rezone the black and brown community, avoiding any environmental polluters next to our home.
There's actually a lot more information about the struggle that that Marsha and her community are involved with in the materials, and I suggest that you read it, because the story is, I was appalled, and I mean, it's just appalling. Can you also tell us some of the barriers that you're facing from the state and local officials? Just some, like, how they're really, harming your community.
Yeah, sure. They passed a bill of the 929, and what the city of Dallas was, they went to try to enforce themselves, and they're trying to avoid any residents filing the amortization complaint, because when they filed the amortization, that allowed the residents to go in and ask for rezoning. But we followed the process perfectly, but when we went down to the city, they avoided that. They no longer wanted to do that. They had $1,000, just went through ZOAG on Tuesday while I was here. ZOAG decided to go ahead and look at it and ask the city to go back and look at it. But that's just still damaging anything that we try to do to avoid any of those polluters in our communities. And that's still not stopping us. As long as we continue having a voice and a fight, we're going to continue doing that. Not only that, they have the SB 471. There's also, if you filed any kind of complaint with the TCEQ, which is Texas Environmental Commission Quality, that if they are not approved, they want the residents or whoever filed them, they want those to be charged as well. And so that's another disgrace to the community. As anybody know, I don't know if you know, but TCEQ is not a friend of the residents. They're most for business.
Okay, again, in the name of time, I'm going to switch to our next speaker, Britney. Can you explain how you've been using civil rights tools in your law and organizing strategy to address the impacts of the North Brooklyn Pipeline Project in Brooklyn, New York?
Sure. So National Grid built a frack gas pipeline through several communities of color in my hometown of Brooklyn, starting in the place I was born and raised and still live, in Brownsville, Brooklyn. National Grid had a whole grand plan, a 5-phase pipeline. 4 out of the 5 phases are in predominantly communities of color. The 5th phase happens to be in the whitest section of Brooklyn. Construction there was halted. The phases of the pipeline lead to a LNG, liquefied natural gas facility, also in the whitest phase of the community. National Grid had a plan to truck the fracked gas through the streets of New York City, and it wasn't intended to serve those communities. It was intended to be transported to Long Island and ultimately to Massachusetts. Fracking, the act of fracking itself in New York State is illegal, but somehow the transportation of this fracked gas through our neighborhoods is not. The trucking the National Grid wanted to do is also illegal. They had to seek a variance in order to do that. Because of legal advocacy, they ultimately withdrew their variance request, so the trucking is off the table. But the frack gas pipeline was constructed and is in operation in the first 4 phases of the pipeline. So for the past 3 years, my neighbors and I, quite literally my neighbors, and I have been organizing. At first, we thought it was to stop the construction of the frack gas pipeline, but ultimately we found out that it was already in operation. It happened with no public hearings, no environmental review, without community knowledge and consent. And so we filed along my clinic, and my students are back there. I want to acknowledge them. So my clinic, yes, students. My clinic, along with our co-counsel at the National Center for Law and Economic Justice, filed a Title VI complaint. That's Title VI of the Civil Rights Act of 1964, like Steve mentioned, which prohibits entities that receive federal funding from engaging in racial discrimination. We filed a Title VI complaint against the New York State agencies, the Department of Environmental Conservation, that's basically our state EPA, and the New York State Department of Public Service, challenging the construction and operation of the pipeline. And that complaint is currently in the informal resolution phase. The EPA and the Department of Transportation are both investigating it, and we just recently actually had a joint meeting about it. So that's how we've been using Title VI and civil rights tools traditionally to challenge the operation of this pipeline. We know we have a tall order, but the community groups that we represent 4 community groups made up of Black and brown folks. The order is to turn the gas off. They turned it on without environmental review, without our permission, and we want them to turn it off. And we know that's a huge ask, but it's what the community wants.
So one question I was going to ask was, what are the barriers that you're facing with your Title VI complaint in light of a lawsuit called Louisiana versus EPA? And in my introductory remarks, I was going to touch on this. For those of you who don't know, the state of Louisiana sued EPA over basically challenging its entire civil rights enforcement program, including this informal resolution process that Britney just mentioned. Rather than go into the weeds on that, can you tell us a little bit more about some of the challenges and barriers you're facing in light of that lawsuit?
Sure. I think the challenges we're facing are probably more subtle. In our joint resolution meeting that we just had, a representative from one of the government agencies that is investigating our complaint, I won't name which, actually said, well, you know, there's a lot of stuff going on with Title VI right now. So that was our sort of subtle hint that while we were telling them all the things that they'd done wrong legally and asking them to redress those wrongs, we were going to be up against the current political climate and actually trying to get them to act. So obviously no one has said to us, you know, we're in the courts right now, we're afraid of Louisiana v. EPA, but we got that impression from sort of side conversations. And like I said, the ask that we have in general is a difficult one because the environmental injustice or the act of environmental injustice that we're challenging has already been quote unquote finished. So even though we have all of this legal evidence of what was done wrong, we have the uphill battle of trying to get them to remedy it in the midst of this political climate where the use of race to challenge these type of wrongs is now being challenged. We're trying to have a process where our clients, who I wish I could have brought them here because they've been the ones who really have been leading this charge. Speaking at these meetings, we also had a site visit where the EPA and DOT came to our communities and looked at the middle of New York City, literally, where the pipeline runs through, including tons of public housing and things like that, and our clients led all of that. So I think we have sort of a double challenge of getting them to fulfill their obligations under Title VI and giving us the relief we want, but also adequately involving our clients. So while we've been in meetings and things of that sort, there are these still side conversations happening between the EPA and the state agencies because that's what the informal resolution process is. Technically, we and our clients aren't parties to that process. And even though this joint process is intended to bring us sort of to the table, so to speak, we're still not privy to all the things the state is telling the federal government about why it can or cannot help us. So I think it's a double-edged sword of navigating Title VI in this political climate and also trying to get the transparency and information we need to actually resolve our problems.
Great, thanks. Quick question to the Taproot crew. What time is this session supposed to end? Oh, we got tons of time. So 12:30?
I have a call at 12:30.
Okay, we'll make sure you're out of here. Okay, thanks for that. Omega, you filed civil rights complaints before, but now you're looking at other strategies. Can you tell us how you're working within a red state to ensure that health agencies comply with their civil rights obligations to address health disparities?
I can. Well, first of all, I'd like to quickly introduce some people that have kept me here for 30 years with our organization. My wife, we celebrated our 49th anniversary in September. She's a co-founder and co-director of the Western Revitalization Association. Attorney Amori Wilson, who graduated from law school in Ohio, and Io, who is the director of clean energy and climate justice for our organization, graduated from here at Central. I just want to quickly mention our organization was founded because we filed a complaint to stop a highway from eliminating our community and another African American, Native American mixed community in Mebane in Alamance County in 1999. And I was identified as a community lawyer. I didn't know what that meant, but that meant somebody in the community who writes their own complaints, because some of the lawyers we work with pro bono did not think we could win and stop a highway corridor from tearing down our communities, churches, dozens of houses. So they read a complaint I wrote, but they would not file an administrative complaint with the United States Department of Justice because they didn't think it would win. But it did win, and it stopped the highway corridor from eliminating dozens of houses, cemetery that goes all the way back to slavery time up to now, and African American churches that date within 6 months after slavery ended, which is right across the street from our house and our office, right? So we have some successes, that's what I'm saying, right? Right now, we are the only county in the state of North Carolina that's been asked by the Governor Roy Cooper here in North Carolina, to incorporate environmental justice for health assessments that's necessary for every county in the country to receive federal monies from the National Office of Health and Human Services. We're working with the state of North Carolina to incorporate environmental justice chapters for all counties in the state of North Carolina. What is interesting about it, what Attorney Steve Fischbach was pointing me to, is that it is kind of odd that these counties do health assessments, but they haven't been addressing the inequities for people of color since the Civil Rights Act of 1964 was passed. How could the counties all over the country and North Carolina evade, obfuscate, and all these other terms you like to use, addressing the health disparities of people of color? The county health officials, who are relatively new, a new staff, came into Alamance County in front of a Confederate monument. We're in a county with a Confederate monument, and asked us, because of our history of dealing with environmental justice issues for almost 30 years, since 1994, would we help them identify health disparities for people of color in Alamance County, which is about 40% people of color. Now we're working with the North Carolina Department of Health and Human Services with at least 10 counties who want to incorporate environmental justice into a health assessment, and about 16 more who are interested in a training model that we're putting together. And we have to work on the other 75 or so in the state. Some of them do not have civil rights organizations in the communities. Most of them, of course, do not have environmental justice organizations in the communities, or any kind of social, economic civil rights organizations in the communities. So we're working to create a training model that is going to be facilitated by the state members of the governor's cabinet to train people in counties to incorporate environmental justice and address health disparities for people of color that is caused by environmental justice and environmental justice sites. Connected to that will be environmental justice order that the governor just signed in October that will be used to map these communities so you identify where the communities are and where the environmental injustices are located based on the proximity of the communities.
I mean, the Omega, the work you're engaged with, with getting county health departments to include environmental justice in their planning is really important, particularly as it could lay the groundwork for lawsuits alleging intentional discrimination. So hats off to you once again, Omega. It's just groundbreaking, the work that you're doing. But can you talk about the role of relationship building and culture shift in civil rights enforcement? Relationships with government, relationships with community, however you want to pursue that particular question.
Well, I think one of the most important things about what we're doing relative to the health assessments, we've talked to some community groups that are outside of the state as a part of a webinar we did with the American Public Health Association. Hopefully a lot of you know what the American Public Health Association is. Asking them what their relationship is with county health officials in their counties where they are. And some of them have very contentious relationships. Some of them have asked for access to talk about health disparities in their counties, but the counties have not allowed them to discuss it. Other community groups that we've talked to in this state and out of state, in various parts of the country, in virtual conferences we've had, virtual meetings we've had, have a attitude that we don't want to work with the government. They've never helped us and they're not going to help us now. We're saying to them at the ground level, the closest agency is your county. The closest agency that deals with health disparities is your county. And this is an opportunity to develop relationships with the closest agency that deals with the fundamental reason we have environmental justice in the first place. The environmental justice was founded on disparities and creating disparities of health, dumping chemicals in your community that poison water, lack of safe drinking water and sewer, factory contamination. And one of the first lines of defense in addressing it is the county where you live. So we're encouraging some community groups, and we hope you will do the same thing, to start developing that relationship with your county officials and the relationship with your state health and human services, because we had to develop that relationship. And reach out, if they haven't reached out to you, reach out to them and start developing those internal relationships. We started with one or two, and now we're working with dozens of people within the state association, and we're also a part of the advisory team for the Health and Human Services for the whole state of North Carolina to incorporate environmental justice principles for the whole state that we're working on with my wife and I.
Okay, turning to you, Albert, where do you see the need and opportunities for using the ADA, the Americans with Disabilities Act, and Section 504 of the Rehab Act to advance environmental and climate justice?
Thanks, Steve. So I'm going to call out some people first to say that, this is a new area for the nonprofit I work for, the Civil Rights Education and Enforcement Center area of environmental justice is a new area, and it's being spearheaded by my colleague, Kate Forstad, who's in a different session. So I'm going to speak to, the sort of thoughts of how we're using the law, whereas, I can't really speak to the community building because Kate is the person who's been really on the ground in Louisiana dealing with some of that stuff. And I also want to call out my co-panelist, Britney Wilson, who's done some scholarship in this area. So what I'm going to tell you about is the way that Creek is thinking about how some of these laws can be used. But I'm sure, well, I think Britney may have some ideas on where I might be going wrong with my thinking. And so I just want to make sure that everyone understands that she's the expert in the scholarship on this area. So what we've been looking at is, particularly, for example, in New Orleans, that basically the disaster planning, evacuation protocols, et cetera, really do not work for people with disabilities. And so we've been looking at how to use the ADA Section 504 of the Rehab Act, as well as possibly even Section 508 of the Rehabilitation Act on addressing some of those concerns and limitations. In regards to, I'll start with 508 because that's sort of the simplest one. If there's, as more and more entities are starting to lean on technology to sort of solve their problems of communications, we're looking to whether or not, for example, FEMA is pushing the use of technology that may not be accessible to all people with disabilities, and to the extent that it is, Section 508 gives you a means of ensuring that inaccessible technology is not used. And very recently, there was a case that held there is a private cause of action to stop the use of that sort of technology. With respect to Titles 2 and of the ADA in Section 504, where you have public entities that are really responsible for doing some of the planning or contracting for the disaster evacuation protocols, et cetera. To the extent that those have a disparate impact on people with disabilities, then that's actionable under those laws, and we're looking at how to use those laws to force government entities to redo their planning to ensure that people with disabilities are not basically left to die in a hurricane, as has happened, as we know, many times, particularly with Katrina and other storms. And then finally, there's a provision in the ADA particularly, sometimes called Title V of the ADA. It's the provisions for retaliation and also interference. And so to the extent that there are private entities that, through their own efforts have contributed to the problem, i.e. they've interfered with your right to have meaningful access to the disaster and evacuation protocols, they are potentially on the hook as well for those violations, and can be made to sort of regroup and do them in a way that does not impact people with disabilities.
And like all anti-discrimination statutes, the ADA and 504 are under attack. And could you talk about some of the challenges and some of the threats to those statutes?
Certainly. So I would say that the biggest problem right now is this perception being fueled by industry interests that the ADA is something that's being weaponized in so-called drive-by lawsuits, where people with disabilities are basically holding up small businesses in order to get a payout because their access ramp was 1 degree off of what it needed to be, or their aisles are 1 inch too narrow, and it's they've been pushing very hard in Congress and in states that have sort of ADA analogs to, cut back on the ability of people with disabilities to, enforce their rights under the ADA. So that's a problem. The courts themselves, under the existing laws, are a problem because they've been cutting back on the availability of emotional distress damages under Section 504, which, given that Title II incorporates 504, there's an argument that that means Title II also doesn't include those. And the reason that that's important is because in order to sort of make these cases, to affect these cases, frequently you'll bring the case, and during the many years that it takes to litigate these cases, the defendant will, fix whatever the problem is in a way that is just good enough to get the court to declare the case moot. And so if you have any damages, you can keep that from happening, and you can usually, therefore, strong-arm the defendants either through the court or through settlement to fix the problem in a way that is meaningful and not just the sort of bare minimum. And without the availability of damages, the defendants are sort of more empowered to moot out the case during the pendency of the action. So I think that really sort of business interests and working through the press to make it seem as if, oh, it's the people with disabilities that are the problem. They're really, causing problems for these poor, benighted business owners who just, didn't understand that, their ramp was off, when really it's more about, businesses that just could care less whether or not people with disabilities have access. And so I would like to think that if any of those modifications to the ADA were to come about either through the courts or through legislative action, would be solely with respect to Title III of the ADA, which applies to private actors. At the same time, I'm sure the states would lobby for those same changes to affect Title II, and that would be disastrous.
Okay, so the next part of our session was to see if there were questions out of the audience that people had for the panels. I'm happy to run around if people do have questions.
There's a mic out there.
Oh, we have a mic there. Let me, if I may, as moderator, just kick off with a question. One of the topics that I didn't feel we fleshed out enough, and this is more for Marsha and Britney, is how are we using the Fair Housing Act? Because we talked about Title VI, we've now talked about the disability statutes. I just didn't feel we gave the Fair Housing Act enough lifting up, so if either one of you would like to comment on that.
Yeah, I will, and I also just want to make another comment. When Britney was talking about the LNG, I think we talked about that briefly previously, and I was telling you Carissa Camacrudo tribe of Texas will be here, and they're also fighting some of the LNG that's harming their sacred land in Brownsville, Texas. And that is something that I like to connect, even on the time, and I'm jumping the subject, but
I
even
would
on the
love
time
that.
of
Thank you.
connection.
Yeah,
There.
thanks.
They're right there. Hold your hands up. Yeah, and I think that'll be a great connection because as we see in our discussion, that even though we're in different states and different parts of the country, that we are still going through the same thing, and much support is needed for Texas as well. And I think it would be very beneficial, as well as Omega. As we were talking about, I would love for you guys to be able to connect with Texas because we have a lot of issues in the state of Texas with the health issue. The county is not helping. And we have a community, which is Sandbridge, Texas. I was saying it has no running water. And it's a mainly black community. It's a former Freemanstown. And we've been working trying to help them with no running water, no sanitation, even in 2023. And Dallas County claimed to be helped. And as you know, that we have people in office that look like us, but they're not for us as well. And so that's what we'll continue fighting as well, because they have the authority. They do not do health assessment. We have a lane plating Superfund site. in Texas. They are not, Dallas County is not doing health assessment on that as well. Those are employees that were there and damaged, but they're still not doing it because they said the lane plating Superfund happened after that company filed bankruptcy. But the people health is still important. So these are some of the things that we're doing with Title VI. The chair is here, he's in a different section, but our lane plate and CAG, we're steady trying to enforce them to test those residents' health. Test their property, we got them to test their property, EPA, but they're not giving assessment to the health. And those are some of the issues we're still doing. Even in my community, as I continue talking, that I've been harmed, permanently damaged because of the environmental pollution. And as you continue to hear me talking, you hear my voice going. And those are some of the issues we continue fighting. Because of Title VI, that everybody should be able to have a fair health. We know they're not doing that, but we're going to continue fighting for that as well. And then we're going to continue having that voice. As they state that even though that is denied, that we're going to continue speaking, because I tell them all the time, just same thing as ADA, that they might not want me to talk too much, reason why that pollution stayed there, but as long as we have sign language, my voice will still continue to be heard. So I fight not only for me, not only for my community or my state, but for everybody else to have this clean air and have the health the same way, permanent. You will not bring that 180,000 tons of roofing shingles near a resident's home and circle around it and take their health away. And so those are some of the issues we have. City of Dallas, they're getting funding, but how can you get funding from federal, but you're not allowing the residents to be able to use that anyway? So that's the reason why we filed the housing complaint, and we're waiting on that, we're pushing that, and they're not speaking, they're still not doing what they're supposed to do for the community, but we still have those fights that we're gonna continue fighting with as well.
And Brittany, did you have anything to add?
I don't, unfortunately, because our complaint is only under Title VI, not the Fair Housing Act.
No worries. No worries. So then let's open it to the audience. There was someone, I think, had a mic.
She's over there.
So go ahead.
Yeah, hi. Hello? Hi, I'm Mary Claire Kelly. I work with Alternatives for Community Environment in Roxbury, Massachusetts.
Can you hold the mic closer to you?
Hello? Hello.
That's better. I had to learn that too.
Okay, I'll say it again. I'm Mary Claire Kelly. I'm an attorney with Alternatives for Community and Environment in Roxbury, Massachusetts. So one thing that I've been thinking a lot about is how with environmental justice, there's a lot of talk about it recently, especially on the federal level and in states like Massachusetts. But no real law has changed so much. So like when it comes to civil rights laws, that often will implicate agencies other than the EPA, because when people hear environmental justice, they think environment, they think EPA. Has like the new emphasis on environmental justice in certain areas of government, do you find that that's helped the fight at all? Like, do you find that that's been useful to you?
Are you directing it to anybody specific?
No.
Okay.
Anyone who wants to answer. Thank you.
All right, well, I'll start off then. Well, I think I mentioned earlier we have an environmental justice executive order the governor just signed, 292 in October, and it is a full environmental justice executive order. Few states have them, right? So how it works at the local level is going to be interesting, because how many of you live in a county with a Confederate monument where people are still fighting over a federal monument? We live in a county, Alamance County, which is a couple of counties over, and it is in court now. The local court, which is in the courthouse where the Confederate monument sits. Confederate monument sits in front of the courthouse. So the court in that courthouse ruled that the federal monument should stay, but the NAACP is appealing that to move it up to a higher court to get the Confederate monument moved. In the past, they've had snipers planted on the roof for anybody to touch it, maybe eliminate it, whatever. And they built a fence around it. It costs thousands of dollars so you could not physically touch it. It's been there for 100 years. I'm just saying that to say the atmosphere of how you get civil rights, environmental justice executive order, even in the state, implemented in a county where you have that kind of revisionism. The Department of Justice, when we first filed our civil rights complaint, Title VI, in 1999, it was a Title VI complaint to stop the highway corridor from eliminating us, just scraping us off the face of the earth, reference the Environmental Justice Executive Order, right? 12898. That was in 1999. So we still have consistent pushback from our county commissioners to implement executive orders, to implement civil rights laws. The county has been involved in a number of lawsuits for the local police department arresting people from protesting, marching, pepper spraying people in wheelchairs, right? Arresting them illegally. The county has paid hundreds of thousands of dollars, and after paying these fines and fees, they gave raises to the police officers that did the work and justice work. The atmosphere of how you implement it at the local level is complicated and complex. In our case, we have a health department officials who stepped out on the law and said, we're going to do our jobs the way the book is written in the face of the Confederate monument. So in a lot of these cases, in a lot of these counties and wherever you live, there has to be somebody that'll step out on the law that protects people of color, that protects your community. And unfortunately, a lot of counties, a lot of cities don't have that, but we have them on the stage, whether they're community leaders or whether they're lawyers. So the strategy to implement all of these regulations and executive orders, you gotta find them, you gotta organize them, and sometimes you have to file complaints like we did in order to make sure they're implemented. And we're still in the process of doing that kind of thing, and I can share some more of that later.
Yeah, like I said earlier, we filed the RCRA that even though when we filed the city adults didn't listen to us, but as soon as we filed that, it went to federal, then they started working to file against those polluters there. And once they filed against the polluters end up having to pay for the cleanup. And so the judge counseled that. But even though they counseled that, denied it, that we still filed it, continue appealing it as well to go to the criminal appeal court in New Orleans. But as I stated earlier, we knew it probably wouldn't go any further because most of them were the Republican judges anyway. But we were still on record that we filed that and we had that opportunity to do that so they can see. It was removed. It did help. We just remediated that property last week. And even though that was $2.5 million of city dollars money, but that didn't stop. The city dollars still have a lot of issues there. You know, Texas is a red state, and they are mainly favored to developers than they are to business owners. And what the city dollars doing now, the slap in our face, that continue our fight, they're putting more developers on that zoning planning commission. And that's still another slap in the face as well. But you know, like we said, we have allies and we have to continue fighting against those. They're just stacking those to try to push the residents out of their homes. And that's not gonna happen. You know, it bothered me so much when I hear people saying that their property has been polluted. All they want them to do is come in and pay them. You're not paying me to go anywhere. That's my property, that's my land, and once you continue doing that, you can go and do it to the next neighborhood, and the next county, the next state, the next city. And we have to continue putting our foot down on what we want in our community. We have a neighborhood-led planned community. We're telling the city adults what we want, not what they want in our community. And you have to read some of those fine lines of those zoning. They try to change it for light industrial, but when we went back, we were going through amortization and authorized hearing in my community to rezone our neighborhood. But once they gave us a plan of what they were gonna do, we had to go back and look at it. No, you still have in fine lines, batch plant. No, we do not want batch plants near our homes. So that's something they have to go back through. It's so easy, they're coming in and tell you that they can do this, they allowed to do it, but you have to be careful and read those zoning regulations and ordinance they have, because they are not permitted to be so close to residents, and that's one fight we continue having. And that's one we continue using as well with the civil rights.
Okay, great.
Okay. Can you hear me? Okay. Thank you so much, panelists. I mean, I am enamored by everything that you all are saying. And my name is Dr. Audrey Elion. I'm co-director of Sowing Justice in Memphis, Tennessee. So I can really relate, especially to Ms. Wilson and Ms. Jackson. We're dealing with major issues in Memphis, dealing with environmental and racial injustices. But one of the questions that I had is related to the things we're dealing with now. So in Memphis, we have this defense depot that's been around since the 1940s. And what has happened is that a lot of pollution, most of the most heavily related toxins with the Army have been put there. A lot of toxins are there, been there since the 1940s. And it was in primarily an African-American community. Based upon that, a lot of people have died. They have had cancer, bone cancer. They've had aneurysms. They've had cervical cancers. All of these different things have happened as a result of the toxins that is now in the ground, in the water line, of what has been going on in Memphis. And so we're constantly fighting that now. And the EPA also came in, and of course they designated it as safe as of today. But we, of course, know that the damage has been done, and now it's historical damage because it's still generational, what we're seeing now, even with the grandchildren and great-grandchildren. So one of the questions that I had, and I put in the WOVA app, what are you all doing, or what can we do to basically get more attorneys but legislators involved, so that way we'll have an opportunity to fight against the federal government, especially when you're dealing with military? How do we do that? How can we forge those relationships to try to get some things done in order to make sure that all of our communities are safe?
Did either Brittany or Albert, did you want to answer it? I just want to make sure that all of y'all get to talk.
Oh, yeah, everybody.
I can.
Oh, okay. Well, we have a situation in Alamance County where the residents who live near a Western Electric used to make telephone equipment. A lot of people don't know. A lot of young people don't know, right? The old kind of telephones you stick your finger in and turn it around. And it worked as a co-location for an Army missile plant underground, 2 stories underground, 3 stories above ground. The facility is 30+ acres. It was originally built as a textile place and converted to military, Western Electric, et cetera. It's been closed for 30 years. We have been working to get it remediated, removed, cleaned up. That's 5 stories above and below ground. So if you spread it out, that's well over 100 acres, right? We have worked with the National Institute of Environmental Health Sciences, a research triangle park, just a few miles from here. We've asked them to be a facilitator as a federal agency to get interagency collaboration, including EPA, Michael Regan's office, HHS at the federal level, Army officials, and we're having a big meeting in Medmond on the 30th of this month. That is a collaborative interagency effort to get this site remediated that's been closed for over 30 years. So we have a similar situation. We have communicated with groups, indigenous St. Lawrence Island, Alaska, people in Detroit, Michigan, Louisiana, Puerto Rico, San Francisco, maybe I'm missing some, Tucson, Arizona, who are all looking at what we're doing in Alamance County as possibly a model for addressing military sites that are in, not on military bases, but in communities that create an environmental hazard that the military should be responsible for cleaning up. We are looking for a speaker from, I won't name them, this has to do with planning and organization, from the White House, expected to be at this particular meeting to address the interagency leverage from the highest office in the land to local, county, and city officials. So we have the same thing. We've organized this big meeting to bring all these officials together to create a strategy for cleaning up the sites. And if this works, maybe we can share information to leverage some of that kind of work in Memphis, in Tennessee, and some other states. We look forward to it.
Was your question about legislators? I was going to say I don't have a good answer to that, unfortunately, because many of our clients, many of our community groups have, I think rightfully so, some reluctance about working with legislators because they feel like this happened under our legislators' noses. Several laws were broken in the construction and operation of this pipeline, local laws, state laws. Some of our representatives get funding from National Grid. And so I think we're in a unique space right now where, especially as the EPA and the state agencies start to draft an informal resolution agreement, we want to, leverage political power if we can, because we want the things that we want to go into the agreement, and we want media attention and all the things that are going to help to persuade them to draft the kind of agreement we want. But we also have been working hard to sort of maintain the integrity of this fight and to respect our clients' wishes. So we've been walking sort of a complicated tightrope in terms of legislative involvement.
One thing I'll just add on legislative stuff, because it's the military, like this, your state legislature can't really go there. So I just want to suggest you work with your congressional delegation. Hopefully you've got some friends in Congress that can advance your cause. Because we are short on time, we wanted also to have some collective discussion. Because this is a breakout group, not just the Talking Heads panel. So this is your opportunity. And we had 2 discussion questions. Hopefully we can get to both of them. But the first one was to start identifying some of the false solutions to problems with civil rights enforcement. I don't know if we've got, is that chart still up there where we can put stuff? So I don't know if what makes sense is for people to write stuff down and to put it up there, or whether we should just have the roving mic if people have anything to chime in on in terms of false solutions. Good. Mike, we need someone here. Okay, got it.
Thank you very much. And this has been a really inspiring panel, or couch, I don't know what to call it. And it's great to see some of you in person after the pandemic, to come together and to, get some energy to take back to where we work. I work in California now. Never thought I would say that, having grown up in Brooklyn. And I, direct the Environmental Law Center at UC Irvine School of Law. And I just want to touch on an issue that many of you have hinted at. In Omega, I'm really inspired by your work in North Carolina, and it makes me think about how one false solution that has bedeviled the environmental justice movement with regards to civil rights is, every administration from Bush 1 on has had senior officials say that environmental justice, or back in the day, environmental equity, is a quote-unquote priority. And we know what that meant, and we know what that meant in practice in various ways. And so one false solution is putting too much stock in, every 10 years, there would be a new turn. I remember as a law student reading some of the articles. Is Title VI a silver bullet? Is the Fair Housing Act a silver bullet? No, there is no silver bullet. I see it more as silver buckshot. I see it more as an ecosystem of solutions. And I want to specifically target, and maybe we can have a conversation about this, the relationship between federal and civil rights enforcement. And I'll just give you a very brief example. Maybe this could encourage discussion. So there are much better versions of Title VI at certain state levels. In California, it's California Government Code 11135. It's like a much more advanced version. How many times has it reached judgment on the merits in several decades? 4. But that's not the point. The point is that agencies in California violate that California statute on a daily basis. We work with a coalition of groups that focus on pesticide reform, for example. We've spent the past year interviewing 50 farm workers in Spanish and English, documenting those civil rights violations that occur not just at the state level, but at the level of county agricultural commissioners. And so our first step was not to file a complaint. Our first step was to hold what is called a people's tribunal, where 100 farm worker families got together in the Central Valley of California and showed publicly that they understand the law, they understand the nature of the violations that are happening every day, and they understand, and this is important, that the agencies responsible at the county and the state level have no capability of knowing when they are violating state civil rights laws. And so that is used as a springboard to now we are considering filing a Title VI complaint against the Department of Pesticide Regulation, but we are also focusing on complaints against the counties under California Government Code 11135. And equally important is to have a legislative strategy that happens alongside all of that to encourage the California State Legislature to require agencies like the Department of Pesticide Regulation to have affirmative civil rights compliance capabilities so they're not flying blind because these violations are happening every day. So thinking about how these strategies can work together and marrying the federal and the state, I think, is key.
Okay, we had there was someone on this side of the room.
May I address that, the last speaker, for just a moment? So,
Oh, go ahead.
I'm encouraged to hear you're using Section 11135. If I recall correctly, one of the requirements in the law is that all contractors with all agencies have to include in their contracts that they will abide by all of the requirements of 11135. And just sort of speaking from sort of experience as a litigator, you know, when you sue governments, they fight tooth and nail all the way to judgment, and it's a pain in the neck. And when you sue businesses, if there is any possibility that they are going to lose, you know, once you sort of get past their like attempt to dismiss the case, they are frequently willing to come to the table, especially in the context of civil rights laws where they know they're going to be on the hook for not only their own attorney's fees, but your attorney's fees if they lose, to sort of say, okay, what can we do to fix this and make this case go away? So I suggest that, you know, to the extent that it's possible to look into going after the, you know, agency contractors who are saying they will abide by the requirements of 11135, that may be an alternate or concurrent target for your, you know, litigation efforts in addition to going after the state agencies.
Hi, thank you. My name is Dana Johnson. I work with We Act for Environmental Justice. I lead our federal policy office in Washington, D.C. And I know, Meg, I was like, come say hi to you and Miss Brenda. But I think a false solution that we're seeing at the federal level, which I think speaks to one of the questions in the back, is like proxies. So the federal government looking for proxies to address what we know are race or civil rights issues. They don't get to the heart of the problem. We see that happening right now. Like, we see the federal government being timid, being shy. And so I was really struck by what was said earlier about, you know, sort of the side conversation around you won't really, you know, gain any traction here, if I'm saying that correctly, or you won't get the resolution that you desire around the pipeline in Brooklyn. And so I guess I'm curious about what is our recourse when the federal government does not enforce the law.
I don't know that I have an answer to that at all, unfortunately. I mean, I think that's why all of these strategies work in concert, right? What did Mr. Shaw just say up here? He said, you know, you fight, you may not win, but you can't win if you don't fight. And I think that's what we continue to try to do. All of the strategies all at once, in tandem all the time. You know, in Brooklyn, we literally had no other recourse. We couldn't sue because the pipeline was constructed years before we found out that it was in operation. So there was no traditional judicial recourse for us. All we had was Title VI. If the federal government doesn't enforce Title VI, then, you know, maybe we continue to lobby the state agencies to do their due diligence. That means potentially working with the legislators who, like I said, all this happened under their noses. But, you know, nevertheless, the community groups that we represent will continue to organize, will continue to push. But I don't know that I have one good answer to that.
I'd like to add something that maybe we haven't talked about, is our successes came on not on lawsuits, but administrative complaints. And I've talked to a lot of lawyers when we filed administrative complaints back to 1999 that wasn't sure exactly what we were doing. But the Department of Justice said, encourage us to file an administrative complaint about planning highway corridors through black and brown communities, because the planning process to use federal monies is very detailed. How the forms are filling out are voluminous. And the administrative complaint process asks, did the state, the city, the county include communities? Did you have public hearings? Did you address the impact to people of color? And when we filed an administrative complaint, we found out all these gaps in the forms the Department of Transportation filed, the city filed, the county filed, and the Department of Justice at the federal level, Federal Highway Administration filed. It was quite true where they said they met with us in the community. They said they had public hearings. They said they had public map showings, and none of it was true. So the administrative complaint locked it down because the Department of Justice said you did not procedurally plan this project and ask for federal money, so it's against constitutional law. We learned something about the administrative complaint process, and the attorneys at the Department of Justice said, this is faster than going through court. Because if we find 2 or 3 things in the process, in the paperwork, which is pretty thick, where these agencies requested federal monies to do something that's constitutionally wrong, we will stop the federal money, we will stop the planning. So that's what happened in our case. So we encourage community groups to file administrative complaints quickly, do it. You can do it now online. There's forms online. They send us paper forms we fill out, and I had to type them in with my typos. It is still out there, and people are still using it at law schools. We encourage community groups to use their community lawyering efforts to file administrative complaints. If you Google United States Department of Justice and search administrative complaint form, they will come up and you can use them. Thank you.
Just 2 quick points. Your question about what to do about federal government's failure to enforce, probably not a whole lot, at least by going to court, because of really bad case law about agency discretion in enforcement matters. I also just wanted to lift up the comment about proxies. In case people didn't understand what that means, it's about using other things as a proxy for race. Because, like for example, like using income as a substitute for looking at how to allocate funds, and this comes from the pushback towards, from the starting at the Supreme Court, about not using race-conscious remedies, even though we live in a very race-conscious society where the consequences of racism are on display, and that's what we're all dealing with. I think we're almost at time. I'm really sorry that this session got cut short, but there will be another one, and I encourage you to attend that as well. So I just want to ask you to give a round of applause to our panelists, including Albert, and let's continue the dialogue.